your terms of use become a vital piece of your legal arsenal because it's going to give you the ground to, one, demand removal, pursue damages, so they can't say that, oh, well, it was an accident. No, our terms of use specifically state that you can't do it or use our content in this way, so now it becomes willful. Hello, and welcome back to the Own Your Genius podcast, the space where we encourage you to use your education and your experiences to create dope businesses. I am your host, brand attorney LaConya Murray, owner of Mark IP Solutions and founder of Mark Legal. This month we hosted our How to Read a Contract Like a Lawyer workshop, and let me just tell you, or let me just remind you how awesome it was. It was packed with so many gems that we couldn't even fit it into our 45-minute allotted time spot. But if you missed it, don't worry. Today, we are sticking with our contract theme, and we're diving deep into how 3 contracts you might encounter every single day actually serve as a powerful legal armor for your intellectual property. We're going to explore what each of those contracts entail, why they matter, and the concrete ways that help you defend your creative work and business assets that you poured your energy into building. And the reason that we're doing this is because this month, a few times, I have had a few of my Mark Legal subscribers and other clients reach out to me and say, hey, how can I just make sure that when I'm giving someone access to certain things that I'm protected? So if you want to know the answer to that question, stick around. Welcome back to the Own Your Genius podcast, where we talk about building smart businesses, creating standout brands, and turning your intellectual property into income. I'm your host, Attorney LaConya Murray, founder of Mark IP Solutions. We're a boutique firm that helps professionals and experts use legal clarity and brand strategy to protect what they've built and grow what they've created. We got a good one for you today, so let's get started. Like I said, we're talking about 3 contracts, and that first contract that we're going to talk about is the term of purchase contract. Now, this is not just for handling sales. They are the foundation of your relationship with your customers and the first line of defense for your intellectual property, especially if you're selling digital products. When someone buys a product or they sign up for a course or download a resource from your business, these terms outline the rules governing that transaction. They cover payment obligations, return policies, and user responsibilities, and most importantly, user limitations for your content or products. And what this means for your intellectual property is that if you have a well-drafted terms of purchase agreement, it's going to explicitly state that all the materials, the digital downloads, course, videos, ebooks, or even physical goods with your proprietary designs are your intellectual property. You can restrict customers from copying, modifying, sharing, reselling, or otherwise misusing what you sold them. By clarifying that the purchase grants them a limited license for personal use, not ownership or commercial rights, you create a legal basis for action if your intellectual property is misused. These terms also help the customer's expectations, reducing the risk that they really are going to misunderstand what they can and cannot do with what you're offering. So if you have a terms purchase agreement, what you want to make sure to do is look at a few key clauses in that agreement. One of them is specifically about intellectual property ownership. You want to make sure that you have a clause that says that all the product and the content provided through this purchase, included but not limited to digital downloads, course materials, videos, ebooks, and proprietary designs, remain the exclusive intellectual property of your business. Another clause that you want to make sure that you include in that terms of purchase is a limited license. Something that says upon purchase, you are granted a non-transferable, non-exclusive, revocable license to use and purchase materials for your personal, non-commercial use only, and that no other rights are granted. So you're being very clear what rights are being granted and what they can and cannot do with your property. And then just, something that says that maybe like a prohibited use clause that says that you may not copy, reproduce, modify, or distribute or sell the work. Those are some clauses that you want to make sure that you're going to include in your terms of purchase agreement. Second agreement that we're going to talk about today, that is, I'm not going to say that it's overlooked. People do use their speaker agreements, but they typically only are concerned about their fee and things of that nature. So whenever you're invited to speak at a conference, event, or workshop, whether that event is virtual or in person, you want to use a speaking agreement during those situations. And just keep in mind that that agreement is for more than just your scheduling and your fees and things of that nature. This contract is an essential tool for protecting your presentations, your slides, your stories, your training resources, all the things that you create for this engagement. It's a contract between you and the event organization that's going to detail your compensation, your travel arrangements, and what you deliver. So are you just doing a presentation, or are you going to do a presentation plus a Q&A? And is that presentation a talk? Is it a panel? Is it a workshop? Those type of things. And it's also going to include terms regarding what you must do for promoting the event, if anything. So it's a great contract in that regard. But as it relates to your intellectual property, right? How does this agreement protect your intellectual property? If you use the speaker agreement correctly, it can and should make clear that all the presentations, the materials, the slides, the handouts, recordings, all that original content remains your intellectual property unless you specifically grant them written permission, right? You can also specify that the event people cannot record, reproduce, or distribute your talk or any of your materials without your explicit consent. What this does is ensure that you keep control over your unique content. You prevent organizers from reusing your talk or your presentation or workshop for future events, or selling it or distributing it without your involvement. You can also include in the agreement that you can outline credit requirements, meaning that if they do, distribute it, they have to always put your contact information with any type of distribution of that video if you want them to. You can use limitations, and you can include use limitations and rights to recordings. You want to make sure that your intellectual property is respected and that you benefit from any subsequent use of it. And that's one of the biggest things when you're working with third-party events. You want to make sure that, yes, they're paying the fee for you to come and do this workshop today, but if they use it tomorrow, you want to make sure that you're also being compensated for that. Just a few clauses that you want to think about including in your speaker agreement is going to be, again, an ownership of material clause, something that says all presentation materials, handouts, slides, and any original content delivered by the speaker remain the sole intellectual property of the speaker, and that no rights or interests are transferred to the organization, all right? Something of that nature. You want to probably include a recording and distribution clause. You want to make it very clear on whether or not the organization can record. So you can say, if they can't record, you can say something like the organizer may not record, reproduce, distribute, or stream, or otherwise share the speaker's presentation or materials without the speaker's written consent. If they can, if you are going to allow them to record, you need to be very clear on what they can do with that recording, right? Don't just let people record your stuff and then they just own it. Because keep in mind, the copyright belongs to the person that creates it. So yes, it's your workshop. You're presenting it. So that part is your copyrighted material. But whoever records it, the person that's recording it, that video becomes the intellectual property of the person that's recording it. So you want to make sure that it's very clear that you are not transferring the rights, that they don't have the right to that. Making sure you have a clause that says permitted uses of the content. So any use of the speaker's name, likeness, or content in promotional materials must be pre-approved in writing by the speaker and must be appropriate, right? So you're giving them permission to use your name, your likeness, maybe some clips for promotional purposes, but you want to make sure that it is in alignment and on point with what the presentation and workshop actually is. You want to make sure that shows you in a good light. You want to not only limit the use, but also approve any type of use that they might distribute. And that use part is negotiable. So if they come back to you and say, hey, we agree not to use your name, likeness, and content outside of promotional material, but we don't have the time or the bandwidth to make sure that you approve it before we put it out. That's something that you all can talk about, right? And even when you talk about promotional use, like how much is promotional use? You don't want to have a 30-minute presentation and they're saying that they're promoting the workshop and they put 25 minutes of it up, right? So be clear on, you can also specify how much of your content can be used for promotional material. And the third contract that I'm going to talk about today, something that you probably see every day, right? If you're on the internet, it's the website terms of use. Your website is your digital storefront where your creativity and hard work are on display. The terms of use, which are sometimes called terms and conditions, are more than just a legal formality. Some people are like, oh, I just got to get these website terms of use on the website. and they've never even read them. I need you to read them, okay? Your terms of use is a written declaration of the rights and expectations for anybody that's interacting with your online content. Your website terms of use really set the rules for visitors that they must agree to in order to access your site, your products, and your resources. They are usually accessible at a link that's in the sites, in your website's footer, like down at the bottom. And sometimes even before someone makes a purchase or creates an account, they have to agree to those terms of use. But how do those terms of use protect your intellectual property? I'm so glad you asked. So these terms formally establish that all the text, the images, the videos, the audios, the downloads, the trademarks and logos, all the good stuff, right, that are on your website, it specifically states that they're your intellectual property and are used with proper permission, meaning that if it's not your intellectual property, then you have permission to use it on your site. That terms of use is going to set up boundaries such as prevent visitors from copying, downloading, or redistributing or commercially exploiting your content. If someone decides to scrape your website for your articles and republishes your work and creates counterfeit products using your photos and branding, your terms of use become a vital piece of your legal arsenal because it's going to give you the ground to, one, demand removal, pursue damages, so they can't say that, oh, well, it was an accident. No, our terms of use specifically state that you can't do it or use our content in this way. So now it becomes willful. And what it does is it's going to help you preserve your brand's integrity and value over what you're creating. Cool, right? So some of the clauses that you want to include in your website terms of use will be an intellectual property statement. Something that says that all content included on this website is the exclusive property of your business, or that you have a license to use it. You want to make sure that you have a usage restriction clause, something that says you may not copy, reproduce, modify, publish, upload, post, transmit, all the good stuff, any content from this website without the express prior written permission from your business. The use of the website to personal use. So visitors are granted a limited, non-exclusive, non-transferable license to access the website for personal, non-commercial purposes only. And then you can also have a clause on there that's something like a prohibition of automated access, meaning the software that actually scrapes for content. You have a clause in there now that specifically states that they can't do that for your website. And this, another clause that most website terms of use have, and it's not necessarily protecting your intellectual property, but it protects you in the case of if someone believes that there's something on your website that infringes on their intellectual property. So you're letting people know that, hey, if you see something on this website that you think is infringing on your intellectual property, these are the steps that you take in order to contact us so that we can determine what the next action is, right? And for all of these, whether it's the website terms of use, the speaker agreement, or the terms of purchase, you could have a clause that says what the consequences of violations are. So what happens if there's an unauthorized use of content? Maybe it results in termination of access, legal actions and liability for damages. Those are some things that you want to make sure that you include so they know, hey, if I violate this, this is what can happen. So let me know in the comments, do you have either of these agreements that we talked about today, the website terms of use, the speaker agreement, or even the terms of purchase? And if you do your agreements address intellectual property to make sure that you're protected? Let me know in the comments. So one of the key takeaways from today's podcast is that even seemingly routine contracts play a role in defending your intellectual property. Don't overlook their power. Make sure that each one of your contracts that you use is clear, specific, and tailored to your business needs. Your terms of purchase, speaking agreements, and website terms each cover different but equally important scenarios for intellectual property protection. I know that when we were going over some of the key clauses, they had the same, some of them had the same headings, but the terminology were just a little bit different to give you a different area of protection depending on how they're running into you, right? Using well-drafted enforceable contracts helps maintain your intellectual property rights sets clear boundaries with customers and collaborators, and gives you recourse if those rights are violated. That's a wrap for today's episode. Remember, your genius deserves protection, and having the right contracts in place is one of the smartest ways to safeguard everything you work so hard to build. Do not underestimate the power of clarity and boundaries in your business relationships. So what I want you to do when you finish this podcast is just take a moment to review your contract terms of purchase, your speaking agreements, and your website terms of use. Tightening up those contracts is a simple but a powerful step toward owning and defending your genius. If you want to dive deeper into protecting your brand and your business, make sure you check out our resources at Mark Legal. Thank you so much for joining me. Let's take this conversation over to ownyourgenius.co. I want you to share this episode with 3 people and have them join you there. But before you go, you know what to do. Make sure you hit that subscribe button and rate the podcast. Until next week, keep building your business, growing your brand, and owning your genius.